Thanks everyone for joining. I was just pointing out to our panelists that this is the only event in my experience in Rocky's history where the entire audience fell silent at precisely the start time of the event. And I don't know if it's the judge thing or what, but in any case, thanks everyone for joining. We have three distinguished alumni jurists with us here today for what is the Rockefeller Center's Roger Aaron Lecture. As many of you know, this brings important speakers to campus to address issues of law, justice, ethics, and public policy under the Daniel Webster Fund and is created by the Dartmouth Lawyers Association in the 1990s. Just briefly, previous Aaron lecturers include people ranging from the feminist legal philosopher at Oxford, Amiya Srinivasan, in 2021, all the way back to Dartmouth class of 1959, graduate and Yale Law School professor Owen Fiss in 1998, and more recently, a distinguished panel speaking about state attorneys general in 2018. So we'll follow that format today, where we have a distinguished panel of alumni judges here to speak about their work. I'll quickly introduce each of them and then our moderator. Each panelist will share a bit about their own experiences. We'll ask a few questions, but a lot of our time will be spent in Q&A with you, so students, please ask your questions. Don't be bashful. Associate Justice James Bassett is a 1978 graduate of Dartmouth College and has served on the New Hampshire Supreme Court since 2012. After graduating from the University of Virginia Law School in 1982, he clerked in the Federal District Court in Boston, worked at what is now WilmerHale in Boston, and spent 27 years at Orrin, Reno, and Concord, working on a range of important issues, including an active appellate practice. After being appointed to the New Hampshire Supreme Court in 2012, Justice Bassett was also appointed by Chief Justice John Roberts to the Advisory Committee on Evidence Rules. Associate Justice Ann Patterson is a 1980 graduate of Dartmouth College and graduated from Cornell Law School in 1983. Justice Patterson then joined Riker Danzig in Morristown, New Jersey for 6 years, served as Deputy Attorney General and Special Assistant to the Attorney General of New Jersey, then returned to the firm, becoming partner in 1992. She served as chair of the New Jersey State Bar Association Product Liability and Toxic Tort Section and an officer and trustee of various attorneys and bar associations in New Jersey. After being appointed to the New Jersey Supreme Court in 2011, Justice Patterson was renominated for a tenured position on that court in 2018. And I'll note that those appointments were by governors with different partisan affiliations, the appointment and then the reappointment. I think I have that right.
That is right.
Judge Christopher Keating is a 1986 graduate of Dartmouth College and of the University of Maine School of Law. He was appointed to the bench most recently in 2021. Before that, he was director of the Administrative Office of Courts for the New Hampshire Judicial Branch, executive director of the state's Judicial Council, overseeing indigent defense delivery systems and civil legal services. Prior to state service, he worked at the New Hampshire Public Defender Program and in Dartmouth's Office of General Counsel. Last but certainly not least, my colleague, Professor Julie Kalish, is a 1991 graduate of Dartmouth College. Her extraordinary reputation as a teacher, scholar, colleague, and community member is known to one and all here. Less known is that she hates long introductions, so I will end it there. Please join me in welcoming our panelists back to Dartmouth. Jim, why don't you start us off?
Oh, well, so I've been fortunate in my career to have been in New Hampshire. So after I left Boston, I came up to the law firm of Orrin, Reno in Concord and worked there for 27 years. During the time I was there, we represented Dartmouth College and Dartmouth Medical Center. I had a practice that involved representing the Valley News, newspapers, magazines, book publishers over the years. I had a case at the New Hampshire Supreme Court actually involving the Xantop murders here at near Dartmouth, where I represented the New York Times and a number of other media outlets trying to get cameras into the courtroom. So that case went to the New Hampshire Supreme Court. I argued that against actually Kelly Ayotte, who was at the Attorney General's office at the time. And it established the presumptive right of news organizations to have coverage and cameras in courtrooms. So I continued my practice until 2012. I was nominated to the court by John Lynch, Democratic governor. I was a Republican. I actually ran for Congress. Some of you might remember that back in 1994 and lost. But at the time, there was we get nominated by governors and confirmed by the Executive Council in New Hampshire. At that time, the Executive Council was Republican, the governor was a Democrat. I was seen as sort of a middle path there, and therefore, even though I was nominated by a Democratic governor, I did get four votes out of 5. You'd only need 3. So I've been on the court for 11 years. When I got on the court, I was the only person who had not been a trial judge for a long time. And so I argued I made the pitch to the governor that it was important to have a different perspective, a perspective of someone who had tried a lot of cases, argued a lot of cases in front of the court. And so I brought that perspective to the court. In the 11 years I've been on the court, 3 of my colleagues have had to retire because they're hit the age of 70, which in New Hampshire, under the Constitution that was adopted in 1784, you have to step down at age 70. So they've left the bench and been replaced by attorneys who have not been trial judges. So we've had a complete flip on the court. There are now 4 of us that were not trial judges, 1 who was a trial judge and has had the experience that Judge Keating has, which is invaluable. So it's a great honor and a privilege to be on the court. I always thought that one of the most fun things that I did was argue in front of the New Hampshire Supreme Court. So now I get to ask the questions instead of answer the questions. So, but it's a great opportunity to help form the law in New Hampshire and deal with very important issues. And so it's a privilege to be there, and it's a privilege to be here with all of you today.
I just want to tell everybody, because I also argued before the court that I'm now on, that it's a heck of a lot easier to ask the questions than to answer the questions. It's just the way it is, and it's a lot more fun as well. Like Justice Bassett, I was in private practice most of my career. I was a government major at Dartmouth. I went on to Cornell Law School. I apparently hadn't had enough cold weather, so I went to Ithaca and came back to my home state of New Jersey and practiced there, was in government relatively briefly. Just really stunned to be chosen to be a nominee to our court. And I just want to give you a little background to what Professor Nachlis was mentioning. The way our appointment system works is it's a gubernatorial nomination. The unwritten rule is that out of a court of 7, no more than 4 can be the member of any one party. So there's party balance, which is a long tradition. And after 7 years, the whole process starts again. The governor nominates, the Senate confirms, and the design of that was to have 2 different governors, presumably two different governors have a say, and 2 different senates have a say in a justice or trial judge as well. And we also have mandatory retirement at 70. So our systems are really actually quite close, although I want to say that Justice Bassett, there's no intermediate appellate court in New Hampshire, and I have no idea how he gets all his work done, because we have in our state 40 intermediate appellate judges who are handling 10,000 cases a year, and the thought of them being without them to me is very frightening. So my hat is off to my colleague to my right. just a little bit of New Jersey history. The New Jersey court system until 1947 was the laughingstock of the United States of America. There were so many courts that no one knew where to file a lawsuit. The High Court, the predecessor court of the one I'm on now, was the largest court in the world. It had 16 members. 6 of them were not lawyers, and apparently they would sit in front and read the newspaper, and the justices who were lawyers would say, vote for this or vote for that. And there were calls for reform for years, but the Depression and then World War II intervened. 1947, they sat in a sweltering gym at Rutgers University for a summer, and they had experts coming in from all over the country giving New Jersey advice as to how to reform its court system. Great advice. I've read virtually every word of what went on that summer. And the result of that is a streamlined system which has worked very effectively for New Jersey. And part of that was this system of nomination and confirmation, and then 7 years, and the next governor has a chance to have a say in who stays and who goes. So.
My experience after law school was as a public defender working in rural New Hampshire. I represented people in juvenile cases and misdemeanors and felonies in Cheshire County and then here in Grafton County, and then opened an office of the public defender program that served the North Country of New Hampshire. That office was located in Berlin. And then I had a brief stint in the college's legal affairs office, and then was asked to return to the public defender's office as the executive director, and I ran the program for 12 years. And it was the greatest experience of my life, running the public defender's office and working as a public defender. We had 120 lawyers throughout New Hampshire. We represented thousands of clients a year. Most of the cases that Jim talks about, our clients stole from the institutions that he represented, so that was our claim to fame. The privilege of representing people in court as a public defender was defining, because you met them at the lowest moment of their lives, and also the moment when you could maybe exert the most influence on them, or the point at which they're finally going to listen, because they're facing jail time, or they're facing some loss of privileges that they'd become accustomed to. And all of the intractable problems of society sort of found their way to our doorstep, whether it was firearms or substance abuse, untreated mental illness, co-occurring disorders. It all just came in a sort of regular and constant tsunami to our doorstep. I took a break from that and ran New Hampshire's Judicial Council for 5 years. New Hampshire Judicial Council sprung out of that same movement that began in New Jersey, that was spearheaded by the Chief Justice of the New Jersey Supreme Court, to create these judicial councils throughout the country that would advise the government about how to structure the justice system in a way that served people most effectively. And also, in New Hampshire at least, they saddled the Judicial Council with responsibility for overseeing the state's indigent defense delivery system and the system that provides lawyers for parents accused of abuse and neglect in the state of New Hampshire. So I was responsible for that. And then slid over and became the director of the administrative office of the courts. I found myself, after 4.5 years of doing that, being responsible for supporting the administrative side of the court system, but knowing not a lot about different parts of the court system. As a public defender, I knew the criminal court system cold. I had it down. But there was just a vast array of cases that I wasn't familiar with, and I felt a little fraudulent trying to help support and administer a system where I only knew a very narrow slice of. And also I had this intense desire to just get back to being the frontline person that I had been as a public defender, had gotten removed from by having these, maybe almost 20 years of administrative roles. So it's been just an extraordinary privilege to get appointed to the trial court bench in the circuit court in New Hampshire, because it's absolutely the people's court. I mean, it handles family cases, and so that's juvenile delinquency, that's abuse and neglect, it's the child protection system, it's people's marital or parenting cases, it's probate, so you deal with trust cases and guardianships of incapacitated adults and minors. And then the district court system, which is landlord-tenant cases and the criminal side of things, and small claims and civil actions. So it's the court that you're most likely gonna need as a human being, because you're gonna get a speeding ticket, or your loved one is gonna get dementia and you're gonna need a guardianship, or your kid is gonna make a bad mistake and is gonna get arrested and you need to go with them to court. And so it's just the daily onslaught of life every single day, in marked contrast to my colleagues here to my right. But I'll tell you, I always, with respect to Justice Bassett, you deal with this constant onslaught of cases, but you're always super mindful that someone's going to be reading the work that you did when it gets appealed. So I'm haunted by Judge Bassett on a regular basis. Not by Anne, because she's a...
No, but you should be haunted by Judge.
Not sure how to follow that. One of the things that's striking me in hearing you talk is, first, that there's a difference between the state court systems and the federal court system. And that I think that most of the time when we talk publicly and are in social conversation sort of these days and in sort of media discourse, we're really talking a lot about the federal system. And we're clearly hearing a lot these days about, judicial philosophies. Are you an originalist? Are you a textualist? Are you a living constitutionalist? A term that we both hate, just to share. And so I'm curious to hear, because that's part of the public discourse so much, to what extent do you actually experience that as a real, part of your job? To what degree does that really resonate with what it looks like when you're doing your work?
I would just say I think that the public perception of the judicial system is dominated by the view of the U.S. Supreme Court and its dynamics, which I think recently has been somewhat unfortunate. I know just in New Hampshire we have, and Chris will correct me if I'm wrong, about 150,000 cases filed in our system every year, and the federal courts in New Hampshire have less than 1,000 cases. So, as Chris said, the place where most people are going to interact with the judicial system is the state court system, and so it's incredibly important, the people who get on the court. It's incredibly important. I tip my hat to Chris and his trial colleagues, because we are incredibly under-resourced compared to the federal judges. We actually had a swearing in this morning, which we did jointly with the federal judges. We have a great relationship with the federal judges, but their lives and what they do are very, very different than what we do in terms of just their docket is very different. We deal with everything, like as Chris was saying, and constitutional issues as well. The federal court is they're more of a statutory court. They deal with constitutional issues as well. But fact is that most people are going to interact with the state court system, and it's part of the whole civics education that's very important in the country, and it's been faltering, that people need to understand the roles of these two systems and the importance of the state judicial system.
And I echo exactly what Justice Bassett said. In our day-to-day work, we are not generally interpreting the federal Constitution. We are generally interpreting statutes that the legislature has passed, and to some extent we are interpreting the intent of our much more recent founders, or our framers in 1947 with respect to the state constitution. But our role as interpreting the statutes that have been passed by the legislature is a very limited one. We are not there to opine on whether the policy of the legislature is a good one. We are not there to second guess the policy of the legislature. We are there to really make two determinations. What did they mean when they used a particular word or phrase? And when there's a constitutional challenge to a statute, we're there to determine whether or not it comports with the Constitution. But we do a lot of interpretation, and there's the terms that my colleagues down here don't appreciate never get used for statutory interpretation. But it is a constant effort on our part to try to make a determination of what our legislature wanted to do and wanted to say. Usually they're clear, but not always, and we have many cases involving statutory interpretation. When we do have to interpret our state constitution, having a 1947 document, charter, constitution, which probably seems like a very long ago time to our students here, but it really is a young constitution, and it's a very well documented constitution with respect to what the intent of the framers was. So in the relatively few cases in which there's some uncertainty about the meaning of a portion of the Constitution, we have pretty good guidance from the framers in our 1947 Constitution. But our daily task, almost daily, is interpreting what the legislature wanted to do.
And I don't really have the luxury of being too high-minded about the stuff. I mean, I quote the Constitution every day to people, but it's all pretty trod upon territory. You know, you have a right to present evidence and call witnesses in your favor. You have a privilege against self-incrimination. I tell people when I arraign them, if you had a lawyer here, your lawyer would advise you that you have this privilege under the Constitution and you shouldn't talk about the facts or circumstances of your case. But all of my work is so sort of much more gritty that I don't get the chance to wonder how contextual the segments of the Constitution are. Although I did have an issue last week. A guy wanted his firearms back after he'd been convicted of a domestic violence offense, and he was very angry that he couldn't have them back.
I just want to make a point in praise of Judge Keating and his colleagues in all the states. One thing that I have totally learned to appreciate in the job that I have is the incredible pressures that are on trial judges day to day. Justice Bassett and I have the luxury of going back to chambers and looking up the law and thinking about it and thinking how we want to phrase something and agonizing over the words of our opinions. The trial judges, Judge Keating and his brethren, have to make on-the-spot decisions under incredible pressures in front of a jury, often with the complications that a jury's presence creates in a courtroom, because the judges have to be extremely careful as to what's said in front of the jury and what is not. The lawyers are not always perfect in how they present issues. It is an incredibly demanding job, and I just want to mention that. I've learned to appreciate it.
I'd just like to highlight one thing that Justice Patterson alluded to, which is when we look at constitutional cases, usually the arguments are made under both the federal and the state constitution. And in New Hampshire, we've had a long tradition of examining the rights under the state constitution first before we turn to the federal constitution. We'll look to federal case law and the text of the federal constitution, but only really for guidance in interpreting our Constitution. There are some states that have constitutional language which mirrors the US Constitution, and they approach it from a lockstep perspective. So basically whatever the federal courts have said about the federal constitution, they adopt for the state constitution. That's not the way it's been in New Hampshire. We have a more robust protection of individual rights under the New Hampshire Constitution. And of course, our Constitution predates the federal Constitution, which is modeled to some extent on our Constitution and the Massachusetts Constitution. So it is an important point that those two constitutions are in play. And as often as we can, we decide cases under the state constitution. We're the last word on that. With some rare exceptions, like the independent state legislature doctrine that's just been in front of the US Supreme Court, once the state has interpreted its own constitution, it can't be appealed to the US Supreme Court.
I'm now fighting an impulse to ask you about that case, but I will resist. I will resist some of that. Another conversation, and first to follow up on what Judge Keating was saying, I was just recently at a conference, and one of the panelists, it was a conversation about, formalism versus functionalism and interpretation, and one of the panelists basically said, that's the luxury of academics, is, that's a whole conversation that you can't get into when things are coming through your court in sort of this rapid fire sort of way. One of the other big conversations, obviously, that's taking place right now, sort of nationally, is about judicial ethics. And I was wondering if you could speak a little bit about sort of the code of ethics that you all follow, and what that looks like and what it's like to work within it. And
Sure. Ours is very simple, no outside income. There's just no question with respect to gifts and this sort of thing at all. And it is very strict. We have a judge who recently retired who wrote a major book which was serialized into a major series that I think probably most of the people here have watched, who couldn't accept a penny for it. And it's a very simple, but it's a very strict code of ethics. I'm very comfortable with it because I think when you are lucky enough to have the responsibilities that all of us have here, you are going to give up some freedoms, and that's fine, because the most important consideration is for the public to know that the judges before whom their cases will go are not influenced by anything other than the merits of the case. So I feel fortunate that my court has been under a strict, and all of our courts in New Jersey have been under a strict code of ethics for a long time. And if we have any doubt, there's a committee that we send a little summary of what the issue is to, and they get back to us as to what it is. And I find it comforting, to be honest. There aren't any close calls that have to be made.
Yeah. New Hampshire, I mean, knock on wood, right? But New Hampshire has a reputation for the bench and the bar to have a pretty darn rigorous sense of propriety and conduct. I think we're extraordinarily lucky in that respect. I have never considered a moment when one of my colleagues, in my experience, would have considered accepting a gift or violating the ethics guidelines that we're obliged to follow. No.
I would just add that our court is under the same ethical code as every other court in New Hampshire, so we're not exempt in any way. Our code does allow outside income up to, I think, 15% of your pay, but I don't know anybody who actually does that. We've got enough going on, so we're not doing that. I would say that because New Hampshire is a small state, our court is 5 people. It's a rare day. We usually have 6 or 8 oral arguments in a day that we're all 5 sitting on all 5 cases, because many of us recuse ourselves if there is any possibility of a perception of that we might be impartial. We recuse ourselves. For example, I recuse myself on every Dartmouth College case. I have 2 colleagues on the court who went to Dartmouth as well, but they're not, don't have continuing involvement with the college. I represented the college. I have continuing involvement today. I'm vice president of my class, things like that. So I don't get near anything that involves Dartmouth, Dartmouth Hitchcock. My wife was a physician there. So we play it safe in terms of recusal. The one other thing that I'd say that's just probably of interest given the situation that we see with the U.S. Supreme Court is, again, we have very few motions for recusal filed because we're pretty sensitive to the issue. But when they are filed, the judge who's been moved to recuse rules on that motion. And then if it's denied and it's appealed, then it goes to the entire court. And then we talk about it. Push has never come to shove in my 11 years on the court. If that occasion arises, we talk about it and the judge makes the ultimate decision, and we've never been in a position to override that. I don't know. I think ultimately it's that judge's decision, but there's been there's very full and frank conversation about that. But again, it comes up very rarely because we recuse ourselves if there's any question about whether we could be impartial or not.
I would like to be able to allow as much time as possible for questions from our audience, and it is tradition at the Rockefeller Center that we try to start with, or no, we do start. We will sit in silence until we get a question from a student first. So, is there, there's a microphone, it will come around, so wait for the microphone to reach you.
No pressure, students.
Yeah, none at all.
Hi, thank you for coming. Can you just talk about what some of the most difficult cases are for you to decide on, and then maybe if they're more easier, or like some of the cases that are more regular for you to just do as your part of your daily diet, sort of, you said, like easier to rule on?
We to start? Well, we have a discretionary docket, which means that we choose the cases that we hear, and most of the cases that we choose are cases in which you can make a principled argument on both sides. And when we have about 1,100 to 1,200 petitions for certification each year. They come to us, and we generally take, there's no magic number, but we generally take around 80 of those. And as a result of that process, we are choosing cases often as to which the merits are really very close. So it's very hard for me to pick out a difficult case or a few difficult cases, because those cases all matter. Somebody's liberty is at stake. Important government issues come to us. There are important policy considerations that the legislature is interested in that come to us on a constitutional challenge, and they are almost all extremely difficult. Every so often we'll have one as to which the merits are not as difficult. It's almost a relief. But the bulk of our cases are really, really tough. Certainly some of them are more heartrending for one reason or another than others, but they are all really important to people involved and potentially important to many more people. So they're all difficult.
Yeah, I would just say I am jealous of Justice Patterson being on a cert court because everybody who tries a case in New Hampshire basically can appeal it to our court. And we get about between 800 and 1,000 appeals a year, and there are 5 of us. So we have to sort through them and figure out which ones warrant careful consideration, and we wind up having about maybe 150 to 200 cases a year argued in front of the full court. I would echo what Justice Patterson said. I mean, if they're going to be argued to us, there are reasonable arguments generally on both sides, and so it's hard to categorize which cases present the most difficult legal issues. I would say that one of the significant changes that's occurred in my 11 years on the court is when I started, we would probably get maybe two cases, parental termination cases or abuse and neglect cases each month, and now we probably get 10 or 15 a month, and they're very painful cases to read. They're very difficult, but the people that, by the time it gets up to us, it's generally distilled down to legal issues, though obviously you can read the personal pain behind a lot of these. But again, Judge Keating hears these cases, and it's been an incredible, it's taxed our court system significantly to have so many of these cases, and I can't imagine actually being the trial judge on most of them. So I, again, tip my hat to what Judge Keating does.
Yeah, there really aren't any really easy cases. You know, like things have, the wheels have fallen off the trolley if something's coming into court. People can't agree about it. If a landlord and a tenant can mediate their dispute out in the hall, and we have professional mediators that the court provides them, then those cases resolve. But if they don't, if they can't, if it's a dispute that's just intractable, and then they're coming in front of me, and we're going to have a half an hour hearing. To what Justice Bassett said about the opioid crisis, I mean, methamphetamine and fentanyl and the sort of just crushing disaster that's been for our communities, and the repercussions are they're broad and they're vast. I sit sometimes in Laconia, New Hampshire. They just cleared out a homeless site of people unhoused. There are 120 people who had been living there throughout the entire winter. And the addiction problems that run through that community of people it's left a lot of children without parents, and it's left a lot of guardianship cases. You can't swing a dead cat in New Hampshire without hitting a grandparent who's caring for a grandchild right now. And so we'll see the repercussions of this. The impact of COVID on the delays in children's maturation and some of the delinquency issues that we're seeing in the school setting. Like, these are like 14-year-olds and 16 or 17-year-old bodies and age levels, and so it's just everything's super hard. So I'd love to be able to say that there were easy cases that I look forward to as being kind of by the numbers, but there really aren't, because I always have a plaintiff and a defendant. I always have a landlord and a tenant. I always have the state and a defendant and the defendant's attorney. There's always a complex dispute. I'll tell you, the hardest thing is, I said to myself, when I said to the body that confirmed my nomination, I said, my commitment is that I will I will try to treat every single person who comes in front of me with the dignity that they deserve as a human being. And that turns out to be easier with some people than others, I've found. So that's like the biggest challenge in half an hour, because my hearings are half an hour in length, by and large. And so and very often I don't have any lawyers in front of me. So in half an hour I need to extract from the litigants all the information I need to be able to do justice by what they need to know, and try to give them a sense as they were participating in this hearing that they were heard. And sometimes my desire to treat everyone with dignity and my desire to extract information from people that I need to do justice by the issue that they have in contention, they are in conflict with one another. And I find I can't do both. So it's very nice and a little naive to say that you're just going to treat everybody with dignity and respect, because sometimes the demand for information, the demand to do your job, and the constraints within which you have to be able to do that successfully, they're just in raw conflict with one another. So I think, so that's hard. So there aren't any really easy cases.
I'll step out here, not in the booth. Hi there. My name is Kyle. I'm not sure which one of you mentioned it earlier, but one of you mentioned mandatory retirement ages for judges. And I'm in a class with both Professor Nachlis and Professor Kalish right now, and in both classes at different times we've discussed ageism and various perspectives on that topic. I'm wondering, and then there's also the sort of national debate around older politicians, older presidential candidates. I'm wondering what y'all's perspectives are on age-based limits, mandatory retirement ages in the judicial system, and whether that differs from maybe your thoughts on them in the executive or legislative branches.
Well, I guess I'll start. No comment on the executive or legislative branches. We have a 70-year mandatory retirement, and it's in the Constitution. What I think of it is of no import to anybody, but I actually welcome it. And I will miss this job when I turn 70 more than I can express. But there are all kinds of diversity, and generational diversity to me is of great value, because the future it should be in the hands as a new generation comes up of that generation. My court has had 3 retirements in the last year and a half. And we have 2 42-year-olds, and just a recent nomination by Governor Murphy of a nominee who was 45. Before the retirements, most of us were in our 60s. I've gone from being the second youngest to the almost oldest in a really short time. I'm in my 12th year. And I welcome working with people who really are of a different generation than mine. They're smart, they're committed, they're passionate, they are extraordinarily hardworking, and I think there's a major value to that. I also, many people at 80 are sharp as can be, and people at, there are judges who are in their 90s in the federal system who are very sharp. What I wonder about is stamina, because the Dartmouth students here, you can stay up till 4 in the morning if you have to do a term paper, and you're fine. I'm 64 and I can't stay up all night anymore, but I can work pretty steadily for a 10-hour or 12-hour day, and I can stay up till 10 o'clock working. I don't know if when I'm 75 I'll be able to stay up past 3 in the afternoon. I may be, but you just don't know. And so I think there is, to me, it's just realistic to recognize that over time, you're not going to be quite as energetic and quite as strong to handle a job. And my job is a 7-day-a-week job. I love that about it. It's extraordinarily demanding. But I think there is something of a value to that 70-year limit.
Well, I think I'm the oldest person up here on the stage. I'm 3 years from when I will have to retire from our bench. During the time I've been there, in the last 5 years, 3 of the justices have retired on their 70th birthday. And they've all been extraordinary jurists, and I think the state of New Hampshire has lost a lot in their retirement. All of them have been on the bench for a long time, brought incredible wisdom, incredible energy. So I think it was a loss for the state that they had to leave. On the other side of the coin, I do think that I've been a judge for 11 years, and it's an isolating job, and you view the world differently, and the world interacts with you differently. And I think that's, I worry about people being on the bench for too long and not being out and mixing it up. So I'm not so sure. I think maybe 75 as an age limit wouldn't be so bad. Not that I intend to go that long, or would intend to go that long, but I do think, for example, in the U.S. Supreme Court, of all the options that are under discussion, and there's some question about whether you could constitutionally impose some sort of term limits, but I think term limits make a lot of sense to me because I think the race to appoint the youngest judge, I don't think is a healthy thing. I think there's some wisdom and perspective that comes from having been out in the tussle for a while, and so most of the judges on my court get appointed in their 50s. I think that's actually a pretty good thing, but I do worry about judges on courts when they're there for 20 years or 30 years or 40 years, as some of the newer justices can be. So I'm torn, but I think on balance, having a retirement age is probably a good thing.
Could I add just one quick comment? I want to get away from judges and retirement ages for a moment, and just to the students out there who may be thinking about a legal career. When you get to our stage, this gentleman is too young to think about this, but you start to see when people retire. When do your friends in different fields retire? And most of a lot of my friends, of course, as you'd imagine, they're either doctors or they're teachers or whatever they may be, and they're really either talking retirement at my age or they're not. Lawyers generally want to die at their desks. They keep going and they keep going, and that is a tribute to how wonderful a profession law is, because it keeps you interested, it keeps you learning, it keeps you young, and most of the lawyers who are my age who I know, obviously judicial retirement is one thing. People continue to work in law firms and so forth after that. They don't have any plans to retire. So I want to just throw that out there as something on the positive column if you are weighing a legal career against other careers. It is so interesting that people do not want to give it up and sometimes just kind of drop over at their desks and are carried out. So it's a plus.
I couldn't add value to that.
All right, it is a good note to end on that question. Other questions?
Hello, my name is Thomas. Just going back to what you were talking about earlier, it sounds like a lot of the experiences you have could potentially be very interesting to the state legislatures that we have in New Hampshire and New Jersey. I was just wondering if you as judges ever have any sort of relationship with them, if they ever come to you for advice on the questions that you see every day, if they ever listen to you, that sort of thing.
We were talking at lunch today a little bit about a lot of what we do is statutory interpretation. As a lot of you probably know, in New Hampshire, our legislature is basically a volunteer legislature, so we get some legislation that is kind of hard to sort out. in front of us. We do our best, that's our job, and so often we do our best, and then at the end of the opinion we say, you know, we have tried to discern the intent of the legislature, but if you think we got it wrong within the bounds of the Constitution, please correct our interpretation. So, but other than that, we don't have, I mean, we have to go to the legislature. I think our relationship with the legislature is much more direct than if you're in the federal court system, because their funding basically is in jeopardy every year. But we have to go to the legislature and ask for money every 2 years in New Hampshire, and that's quite a dialogue. So that's the main time that we have the communication with the legislature. But in terms of substance and whether they agree or disagree with our decisions, their response will be with new legislation.
And we do something very similar in opinions, not many, but the last paragraph will be, here's what we think. If we got it wrong, legislature has the authority to change the statute.
I had the House Criminal Justice Committee come into my courtroom to watch a morning of criminal cases, and it was just wall-to-wall cases and people and interpreters and people crying and people being let out of the courtroom in handcuffs and people being brought in orange uniforms, and it was really eye-opening for them, because there's a real disconnect between, so it's a volunteer legislature, right? So I think the average age is 65 in the legislature. So, and you have to have a certain amount of privilege to be able to have the time to spend all your time at the legislature. So generally speaking, these people aren't, having jobs that would interfere with that. And so they don't always get to see what life is like in a courthouse. And I absolutely loved it, because they hear reports about what happens in the court system, but then they got to see it right up front, and they got to see just the grinding problems. Like our public defender system in New Hampshire right now has tremendous delays in getting lawyers for people. And it's a real violation of the Constitution, and it's happening every day. And they got to see it in action. They got to see someone come in from northern Maine, make it to Concord for a further case status hearing, and say, my case hasn't been taken off the hold list yet from the public defender's office. Holy cow. Someone drove from Maine and took a whole day to be able to come to court to accomplish nothing. And the legislature got to see that, and it was magical.
Well, I would just say I'm glad to hear that story, because we at the branch and at the Supreme Court, we've asked for a substantial increase in funding for the legislative branch, for judges and for staff, particularly in the circuit court. So to the extent that they can go see how this all plays out in real life, that's tremendous.
Could I just follow up on precisely this line, which is the capacity issue, and then a lot of the problems that you've spoken of appearing in your courts are really, they're social problems first and foremost, or structural issues that then end up in court. And so when some people see this, they favor either expanding the judiciary or expanding what some think of as alternative courts or problem-solving courts, like domestic violence courts, drug courts, mental health courts, veterans courts. And I'm wondering if you view that as sort of a favorable addition to the judiciary, or sort of supplement, given the problems with your own workloads that you described, or whether you think that those things are too far from courts and suddenly we're sort of creating social service agencies within the judiciary, and that's a bridge too far.
I'm an outlier on this. And it comes from my time as a public defender, and I was just very wary of personality-based courts that relied on the enthusiasm and the dedication of a particular judge without without all the infrastructure sort of necessary, and without a broad application statewide. So you'd have a really dynamic, interested, engaged judge in one community who is having a drug court, but then the next town over that doesn't have access to that because the judges there aren't interested in it. And I worry about courts just being courts and being good at that. And I've always been, hey, you know, in a desert, somebody with a cup of water, that's, you know, that's fantastic. And so maybe drug courts and mental health courts are cups of water in a desert. But I'm very wary of, I'm personally wary of courts trying to fill in the blanks for the lack of resources in communities. But I'm an outlier on that.
We have had a very good experience with what we now are calling our recovery court, which is our drug court. Not 100% graduate by any means, but I think it's turned lives around in a very big way. So our experience with that type of court has been positive.
I mean, we've had limited experience. It's been good in New Hampshire with drug courts and all, but what Judge Keating says is true. It's sort of catch as catch can, and you need a judge who's really invested in it. And most of the funding we have for those types of courts comes through the federal government through grants, and we don't have robust funding for those types of alternative venues. I think the way we see it is we just want to make the court system run as well and as efficiently as it can, and that involves having staff and having enough judges. We just had a study done of workload for both staff and judges, which identifies a significant shortfall, particularly in the circuit court. So our number one priority in the legislature and as a court and as a branch is to get more funding for those core responsibilities that we have.
We have about a minute left, and so a minute and a half. And so I'm going to close. Well, first, I want to just take a moment and just draw out, I hope you have seen and appreciated just how seriously every one of these people approaches their job. And Justice Bassett started out his comments by saying, I wrote it down, by saying what a privilege it felt to you to be on the bench. And I think all of you have articulated that in your own different kinds of ways, and how seriously you take your job and the fact that you're dealing with human beings who have very human problems. And so, but to sort of close on a again, somewhat traditional Rockefeller Center close is piece of advice for our students. One piece of advice for our students. It can be about anything.
Well, I'm going to make a pitch for the law. There's no surprise there. And you know, when I was here, I was telling Justice Bassett at lunch, I was one of those awful kids who at 10 announced I was going to be a lawyer. And I got my first job in a law firm at 14. I mean, I was just, nobody could stand me. So I was not anybody who needed persuasion. But I could see from where you sit, students, there's so many options. There's so many, law school is a difficult commitment. It can be expensive. It is difficult. It's 3 years, and you're wondering, weighing that against the other options. A law degree will make you stronger and more capable of helping people in any field that you ultimately end up in. There are just lawyers who are doing terrific work in all kinds of fields and using their legal backgrounds. But I think it is as rewarding a profession as there ever could be. So I just want to make a pitch for thinking very seriously about pursuing a legal career for the students.
I concur with Justice Patterson on that. The one thing I would say is that, unlike Justice Patterson, I didn't know I wanted to be a lawyer until I'd kind of become one. I thought law school was really interesting, but I've come to appreciate, I mean, it's intellectually fascinating, and and you can accomplish so much as a lawyer to help people, and you can make a huge difference. So I would just say, a lot of people ask me, well, how do you become a judge? Well, I think do your job well. Whatever job you have, do it well and do it with passion, and you can make such a difference in the law, as Justice Patterson says. And I think whatever job you have, do it well, look for opportunities. Doors will open in the most unexpected ways at the most unexpected times, and if you're committed and you're intellectually curious and you're energetic, good things will happen, and you can make a huge difference. And that's all you can ask in life, really.
This is going to sound sanctimonious, because it is, but try to find a way to develop the skills necessary to serve the least fortunate in our communities in a humble way. I think our times really demand that right now. I see a lot of fractious anger in the courtrooms, in the family dynamics, and in people's lives, and I think we've got to find a richer way to serve our communities.
Oh, I couldn't ask for a better close. Thank you. Thank you all, and thank you all for coming, and yeah.
Thank you, man. That was great.
So enjoy it.